recently the Law Commission of India has recommended a stricter regime in the applicability of the sedition law. Contrary to the observations of the Supreme Court, that this is a colonial law, it has served its purpose during the times of the British, and in that context suspended further FIRs to be lodged. You must understand that conceptually the Law Commission has really not understood as to why the Supreme Court said that. There is in law the concept of the government and the concept of the state. Sedition law in colonial times dealt with agitations against the government of the day, not with reference to activities against the state. So any agitation against the government would result in filing a case under the sedition law, 124A of the Penal Code, whether it was against Gandhi ji or it's against all the national leaders. कोई भी सत्याग्रह होता था तो sedition laws पे लागू किया जाता था, क्योंकि वो सरकार के खिलाफ होता था. Then we became a republic. The republic represents the state. The government doesn't represent the state. Therefore, this sedition law has lost its relevance because we have a fundamental right under Article 19 to protest against the government. But we don't have a fundamental right to destabilize the state. 124A of the Penal Code deals with agitations against the government, which is part of our fundamental right under Article 19(1)(a). The UAPA, for example, is a law that prevents activities against the state. So if you incite violence against the state, you'll be prosecuted under UAPA. If you incite disorder that results in violence against the state, you will be prosecuted under UAPA. But if people are sitting on dharna and the police officers comes to the conclusion that this has a tendency to incite violence, you will be prosecuted under the sedition law. Any dharna, any satyagraha, any agitation, farmers' agitation, women wrestlers' agitation. And see what the law says. The expression tendency means mere inclination to incite violence, forget that, or cause public disorder. So any tendency to cause public disorder may result in life imprisonment. I mean, has the Law Commission been commissioned to do this? Has the Law Commission been commissioned to make such a proposal, to try and strengthen the hands of the government? I am shocked that the Law Commission does not itself understand the difference between government threat, public disorder in the context of agitation against the government and public disorder in the context of agitation against the state. That is dealt with under the Code of Criminal Procedure. This is dealt under sedition. And even the Law Commission does not understand that difference. I am absolutely amazed. That's number one. So therefore there is complete conceptual confusion. इनको ये नहीं मालूम कि सरकार और स्टेट का अंतर क्या है. कभी लॉ कमीशन की रिकमेंडेशन जो राइट अप मेरे पास है, कभी वो सरकार की बात करते हैं, कभी वो स्टेट की बात करते हैं। इतना नहीं समझ कि जो अगर सरकार के खिलाफ जो कोई भी एजिटेशन होती है, वो एजिटेटर्स का हक है आर्टिकल 19 के अंतर्गत। विदाउट एजिटेशन सरकार तो वैसे भी नहीं सुनती। एटलीस्ट एजिटेशन के द्वारा बात जनता तक तो पहुंचती है, सरकार ना सुने लेकिन जनता तक तो पहुंचती है। और अगर आप ये डर पैदा कर दो लोगों के मन में कि अगर हम सड़कों पे जाएंगे, प्राइस राइज पे एजिटेट करेंगे या फार्मर्स एजिटेशन करेंगे तो हमें उम्र कैद हो सकती है, तो निश्चित रूप यही मानसिकता है सरकार की कि सारी एजिटेशन बंद करो, भय फैलाओ लोगों के मन में, ताकि वो सड़क पे आ ही नहीं। उन्होंने कहा है कि ये भी एक सुझाव दिया है कि 154 धारा 154 आईपीसी के अंतर्गत under section 154 of the IPC, you can put in a provision that there should be a preliminary inquiry. There may be a preliminary inquiry before you proceed against a particular individual under the sedition law. But preliminary inquiry तो CBI भी करती है। वो क्या है, आप देख लीजिए CBI में होता क्या है। मतलब कि एक कानून, ये कानून और ऐसे कानून हथियार बन गए हैं। दे हैव बिकम इंस्ट्रूमेंट्स ऑफ ऑपरेशन। सरकार के हाथ में हथियार देना ताकि आम जनता कि अगर कोई जनता एजिटेट करना चाहती है, अपनी मांगे रखना चाहती है, उसकी भी जुबान बंद कर दो, साइलेंस हिम। कहने का मतलब ये है कि I am disturbed at the recommendations made. These recommendations themselves are contrary to the ethos of the Republic. They are contrary to the very essence of the Republic. They are contrary to the foundations of the Republic. They give the status, they have given status of the government as if the government is the state. Government is installed through the will of the people. It doesn't represent the state. It works for the state. Conceptually, this is a law which is conceptually flawed. Let me tell you another thing, कि 2014 के बाद लगभग 10,000 से ज़्यादा केसेस सेडिशन के रजिस्टर हुए हैं और सेडिशन के द्वारा कार्रवाई हो रही है। उसमें से मेरे ख्याल 329 लोगों की कन्विक्शन हुई है। अब इसमें कई मैटर्स में कार्रवाई चल रही होगी, चार्जशीट अभी फाइल नहीं होगी, लेकिन कुछ आंकड़े बताते हैं कि कन्विक्शन रेट लगभग 7.5% रहा है। तो आप सरकार के खिलाफ कोई एजिटेट करना चाहे, उसकी ज़ुबान बंद करना चाहते हो और सरकार को ऐसा हथियार देना चाहते हो कि जो भी बचा खुचा है इस देश में रिपब्लिक का, वो भी ख़त्म हो जाए।